I would like to start this, this presentation with a hypothetical that I hope will illustrate some of the points we're going to be talking about today. Suppose that in your country, the 20 largest media companies decided to form a joint venture to collect news together. The 20 largest television networks, radio networks, newspaper companies, websites, the 20 largest media companies want to form a joint venture to collect news. Well, would there be cost savings from this joint venture? Surely. Tremendous efficiencies from this news gathering joint venture. Would it lead to any price increases? I mean, after all, this news-gathering joint venture would be competing for advertising dollars with a whole host of organizations. It would be competing for personnel with a whole host of organizations. I'm not sure there would be any price increases from this huge news-gathering joint venture. But maybe some of you are more creative than I am. Maybe some of you could find some price increases as a result of these 20 large media companies getting together for a joint venture. So, as a condition of being allowed to form this joint venture or merger, these 20 companies stipulate they will not raise the price of anything. Not of a newspaper, not of advertising rates, of nothing. Okay? So here we have this joint venture, the 20 largest media companies in your country. No price will go up, they guarantee it, and tremendous efficiencies will result from it. How many of you would permit this joint venture? May I see a show of hands? How many of you would permit this media joint venture? How many of you would not permit this media joint venture? May I see a show of hands? Almost every hand went up. Well, wonderful. Welcome to the consumer choice approach to competition law. And the reason I say this is because the best way to analyze a merger or joint venture, such as the one I described, is not in price terms. It's not in efficiency or cost savings terms, but rather it's in terms of consumer choice. It's in terms of non-price issues. It's in terms of the variety, quality of perspectives of news that would be presented or generated after this merger. Okay? I would now like to back up. Now that I have your attention, I'd like to back up and put these consumer choice issues into perhaps a larger context. Those of us who are from the United States take great pride in our antitrust laws. Most of us in the United States believe that our antitrust laws are the best and most sophisticated system of competition laws in the world. But we boast a lot, but if we were being honest, we would admit that our system of competition law has a glaring weakness. In fact, an unforgivable weakness. We do not have a single or even multiple goals of our competition law. No one in the United States can tell you what the goals of our system are, which is really an inexcusable way to have a system of competition law. We've had these for more than a century, and we still can't tell you what our laws are all about. Now, in the United States today, there's an almost universal consensus that only economics counts. Okay? Almost everyone will agree with that. Big is bad, small is good doesn't count, harm to competitors doesn't count, politics doesn't count. It's only economics that counts in the United States. But what kind of economics counts? What counts within the umbrella of economics? Okay? Now, efficiency counts, of course. We all want a more efficient economy. Our friends at the University of Chicago will tell you the only thing that counts is economic efficiency. Okay? But is competition policy nothing more than just a quest for economic efficiency? Well, another possibility is the price to consumers approach. Or you can call it a wealth transfer approach or a distributive approach. I mean, as you know, when a cartel raises prices, it causes more than allocative inefficiency. It causes a transfer of wealth from consumers to the cartel. Now, you could call this the theft explanation for competition law, the belief that these laws are inherently about preventing stealing by companies gaining monopoly power, stealing from consumers. Okay? So that is another way to look at competition law. And I recently wrote an article showing that U.S. cases are better explained by a concern with these wealth transfers than with just a concern with economic efficiency. That is, economic efficiency is important, but so is the transfer effect of market power, the transfer from consumers to the cartel. Okay, so in the United States, we have antitrust laws that are concerned with efficiency, for sure, and that are concerned with the transfer of wealth from consumers to firms with market power. But is that all? I mean, what about non-price issues? What about quality, variety, service, and privacy? How do they figure into it? There's a recent Supreme Court decision, not quite on point, but close, the Legion decision, and it said, it is desirable when competition gives consumers more options so they can choose among low-price, low-service brands, high-price, high-service brands, and brands that fall in between. Now, I wish I could give you a clear, unambiguous statement from the U.S. Supreme Court saying what U.S. antitrust law amounts to is consumer choice. I can't. There is no unambiguous statement. But I can show you a number of cases that are best explained by a concern with consumer choice or non-price issues, as opposed to a concern with efficiency, as opposed to just a concern with price. Now, with this as background, the remainder of my talk will first try to define, at least briefly, the consumer choice approach to competition law. And then I'll give a number of examples where a consumer choice approach would make a difference over a price approach or an efficiency approach. Now, you might be wondering, well, what is a consumer choice approach? How does it differ from an efficiency approach, from a price approach? Well, look, briefly, it includes both. I mean, it includes price because price is an important option that consumers want, of course. And it includes efficiency because efficiency leads to more choices in the long run. One aspect of efficiency is innovation, and of course we need innovation for long-term consumer choice. But crucially, consumer choice gives a heightened concern with non-price competition, every significant aspect of non-price competition that consumers care about. Think of it as the difference between the text of an article and the footnotes to an article. Under the other approaches, as a practical matter, non-price issues are put into the footnotes and then too often forgotten about. Under a choice approach, non-price issues are brought into the text of the analysis where they're given much more weight and they make much more of a difference in the analysis and in the results. Let me make a few notes before I move on. Okay. First, not every decrease in consumer choice counts. It's got to be a significant decrease in consumer choice, of course. If it's from 10 choices down to 9, well, you know, we don't care about that. How could we? Second, to echo a comment the President made in his introductory remarks, the goal shouldn't be to maximize consumer choice. The goal should be to allow the forces of competition to set the optimal level of consumer choice. The goal should be to find those practices that interfere with the level of consumer choice that the free market would have set. So we're after optimal consumer choice, optimal being defined as whatever the free market would bring, not maximum consumer choice. And it also should be noted that not every decrease in consumer choice is a competition law violation. I mean, after all, if a monopoly decreases its range of offerings, that's perfectly legal. It doesn't violate any competition or antitrust law. And similarly, as Neil Avert will say later today, some restrictions in consumer choice are in fact consumer protection violations, not competition law violations. Okay. Now, at this point, I would bet that a large number of you are asking a very profound question. That is, I bet a lot of you are saying, of course we all care about non-price competition. Of course, variety and quality and service and privacy, of course those should figure in very prominently in competition law analysis. Okay? But you're probably also thinking, look, if a market is competitive in price terms, won't it also be competitive in non-price terms? So if we focus on price competition, won't that automatically give us the non-price competition that we really want? I mean, for example, suppose an industry has 4 firms, and 4 firms is enough to have price competition. Won't those same 4 firms competing give us optimal levels of non-price competition as well? So if so, let's just focus on price competition. It's simpler. Well, normally that will work, but not always. Not always. There are other times when a focus on non-price issue will yield a very, very different answer, different analysis and a different answer, and I'm going to spend the rest of my time focusing on these times. And as you'll see, in every instance, the consumer choice approach, considering the non-price issues, will yield a better answer, one that is more reflective of true consumer welfare. Okay, there are 3 categories of cases when this will happen. The first category involves conduct in markets with little or no price competition as a result of regulation, of industry-wide joint ventures, or of third-party payers. In these cases, there's simply no way to truly assess the effects of a practice on consumer welfare if all you do is focus on the price issues involved. Let me give a U.S. example. Forgive me, but I only really know U.S. examples. We used to regulate airline rates in the United States. We regulated the prices that airlines could charge, but we expected them to compete in terms of service. One might ask, why didn't we just allow every United States airline to merge during this period? After all, the rates were regulated. How could there possibly be any harm from such a merger? Well, the answer is we wanted service competition. That's why we didn't allow these airlines to merge. And in fact, a very similar thing happened in a small market where I live. There were a number of competing taxicab companies, and their rates were regulated. So they went to the regulator and said, let us merge. We'll be a monopoly, but you regulate our rates, so what could be the harm from this merger? And they allowed that merger, and there's now a taxicab monopoly where I live. Well, you can guess what happened to service competition. Service competition went way, way down. Now, this is a merger that simply could not be analyzed adequately in price terms because service competition was absolutely crucial. A second category of cases where a price or approach simply will not work involves conduct that increases consumers' search costs or otherwise impairs consumers' decision-making ability. This conduct tends to cause consumers to obtain products or services less suited to their needs, in addition to producing price effects. There are many, many examples of United States cases, and again, I have to give U.S. examples, but I'm sure you can fill in European examples that are virtually identical. In the United States, we've had a whole series of advertising restriction cases. Lawyers, dentists, engineers, opticians, and on and on and on restrict the advertising that they can do. Now, in every one of these cases, the goal of the advertising restraints was higher prices. Of course, that's why they restricted their advertising, okay? But in addition to having price effects, every one of these practices made it harder for consumers to find a dentist that was optimal for their purposes, a lawyer, an engineer, an optometrist, on and on and on. So in addition to having price harm, there was non-price harms from every one of these advertising restraints. Now, almost all of these advertising restraints were analyzed under the rule of reason. Or to put it another way, for every one of these practices, efficiencies were claimed. And depending on the case, sometimes the efficiencies was a little more believable, and sometimes the efficiencies were a little less believable. Okay? So we have a rule of reason with the price, the negative effects against the efficiency effects. If all you're going to do is balance the negative price effects against the efficiency effects from the advertising restraints, you might get one balance. But if in addition to the price effects from the practices, you also throw into the hopper the non-price effects. The fact that the advertising restrictions makes it more difficult for the consumer to find the optometrist, the dentist, the lawyer, whatever it happens to be that suited their needs, then the rule of reason analysis might come out very, very differently. Another important illustration can be found in a recent Federal Trade Commission case, the FTC's recent Realcomp case. This involved a conspiracy among traditional full-service real estate brokers to eliminate real estate brokers that only provided some real estate brokerage services. So it was a conspiracy to eliminate them, and to say, so from a consumer point of view, the only thing left was a full-price, full-service real estate brokerage company. And the Federal Trade Commission, and on review the courts, held that consumers are entitled not just to have real estate brokerage services priced at the competitive level, but they were entitled to have an array of real estate brokerage services. The full service high price option and the partial service low price option. And they held that even though no price had actually increased, that is, there'd been no evidence that the price of any real estate brokerage service went up, by eliminating the low price, low service option from the marketplace, that was a violation of the FTC Act. The final category of cases where it should make a difference whether we focus on non-price competition are cases that involve firms that compete primarily through independent product development and creativity rather than through price. In these markets, effective competition sometimes may require more independent centers of decision-making than are required for price competition. In these sectors, we often care more about diminished consumer choice, that is, competition in terms of innovation, variety, and perspectives, than we do even about price competition. Now, the media is perhaps a poster child for an area where we care about more than just price. We care about perspectives. We care about quality. This is why my introductory hypothetical was from the media sector. But there are many more areas of our economy where we care perhaps more about non-price competition than about price competition. It's especially true in the high-tech sector, where innovation is especially crucial. In fact, it's virtually meaningless to talk about a price standard for a product that does not yet exist. What we want is innovation. We want different perspectives, different people trying to innovate, and it's less important to worry about the price of a product. We just want the product in the first place. This is often true for cases, especially in the defense sector, the pharmaceutical sector, computer or other high-tech sectors, where we care about current and future consumer choice, perhaps even more than we care about price. That is, in these markets, we care about competition in terms of innovation, ideas, quality, and variety, perhaps even more than about price. There have been any number of high-tech cases where, and some of them are not very explicit, where you have to read between the lines and you find the decision maker in defense mergers, in pharmaceutical mergers, saying we need more sources of innovation than we think would normally arise. So we're going to block this merger because we want there to be another competitor out there innovating to make sure we get the next generation of pharmaceutical products, the next generation of defense products. I can give a number of Federal Trade Commission cases and Department of Justice challenges that can best be explained in these purposes, in these terms. Even though these cases are examples of consumer choice in an implicit sense, I would like to close with a famous United States case that was explicitly decided in consumer choice terms. Not only was the reasoning and the decision explicitly in consumer choice terms, it couldn't very well have been analyzed or decided in either price terms or efficiency terms. And I'm referring to the case that I expect everyone in this room knows about, and that is the United States Microsoft case. Surely the preeminent US case of the last generation. As you know, the products in question were PC operating systems and browser. If you read the relevant briefs and court decisions, you'll see that the focus of everyone concerned was with short-term consumer choice and long-term consumer choice, and in particular, the long-term consumer choice that innovation would bring. little attention was paid to the price of anything. I mean, after all, Microsoft had a legal monopoly on its operating system. The price of the operating system was not an issue. Microsoft was giving its browser away. That just wasn't an issue. Cost savings didn't even really enter into the analysis, except in the tiniest, most insignificant fashion. Rather, short-term consumer choice and long-term consumer choice brought by innovation, that was the focus of everything in this case. Now, of course, both sides disagreed about how to maximize short-term and long-term consumer choice, of course. But the important point for our purposes is the focus of the analysis and the focus of the results was consumer choice. Now, I'm urging that competition law shift to a more explicit focus on consumer choice. But I'd like to remind you or emphasize that the United States Microsoft case should remind us of two important points. First, antitrust law in the United States is in the process, has long been in the process of evolving towards a consumer choice approach. Even if many of the cases don't always explicitly use the consumer choice terminology, they are best explained this way. And finally, a price or efficiency analysis often is a simply inadequate way to address many of our most important competition-related concerns. Both the Microsoft case and the large media merger joint venture I started with just are not explained very well in terms of price or efficiency unless you torture those concepts beyond all recognition. Rather, they can best be explained, reasoned, and decided in terms of consumer choice. And I would respectfully urge that the consumer choice framework be adopted much more generally. Thank you very much.